And that was for the second-degree felony offense in possession of a controlled substance. And then in October. Okay. September of 2017, same date, also put on a 5-year adjudicated probation for the state jail felony offense of possession of a controlled substance, cause number 17-2669. And so this is 17-26688. We were previously in court. Mr. Barlow entered pleas of true to counts 3, 5, 6, and 7. So we're just here in the second-degree felony. The other one's already expired. I received an updated report. If you both had an opportunity to review that report.
Yeah, Judge.
Yes, Judge. Any additions or corrections?
Oh, not from the defense judge.
Not from the state judge, other than I think we have all previously discussed this before, that the new offense allegations all occurred in Harris County, and we waited some time for those to resolve themselves, which is why we're not proving.
Okay. And they haven't resolved themselves,
No,
or they have.
No, we're currently set for trial next month. I want to say the 20th or 22nd of July.
Well, okay. So what he pled true to was failure to remain in Jefferson County, failure to report the arrest, positive urinalysis, and failure to pay fees. And everything else had to do. Let me double check. Yeah. Okay. So everything else has to do with the cases over there.
Yes.
All right, Mr. Lewis, and there was no agreement. Mr. Lewis, you may proceed.
Well, Judge, since he's been on bond, he's been on house arrest. And I think that probably was one of the best things that happened to him, because it allowed him to, one, find stable employment, which he's been able to do. And recently been able to actually find a nice, stable housing situation for him and his children. He's basically operating as a single parent, because his wife still legally his wife. She's in Harris County. He's here with the children. He's raising the children himself. So he's been able to find employment, find housing, and he's been doing this on his own. He's currently even. You got to see the bandages there. He had a situation where he had a burn incident, and he still was able to continue employment and continue working to take care of the children. So I know that the recommendations, of course, of probation have been either ISF or some type of zero tolerance of high risk caseload. We would ask that he will be placed on some type of high risk caseload where he will be able to continue that on, because I think any type of incarceration right now would be counterproductive with all the progress he's made over the last few months, Judge. And given his motivation, I think it'd be really good for him if we can continue that on, to especially taking care of those children.
Ms. Golfino?
Judge, I'd like to see if Mr. Kitchens has anything to add other than his report, and I have a couple comments.
He has been doing, since he's been on bond and house arrest, I will agree with Mr. Lewis saying he's got a different attitude. He has been tested positive with the probation department, and it sounds like it's made a difference.
Okay.
And that's what I wanted to see, Judge, if he concurred with that. I would agree with Mr. Lewis that as many times as we've dealt with Mr. Barlow on this case, on other issues in the past, I mean, I felt like I've had him on my caseload for 5 or 6, 7 years. I don't know that derailing him now is beneficial. I know that the issues with this female friend or wife or whomever is obviously, you've got to get that straightened out.
I'm sorry to interrupt. What's the long-term?
Actually, when y'all put me on house arrest, that kind of like it was hard for me to get away from because of my wife and my 2 kids. When I put in my hospital, I've been on it for 6 months. So no contact, only way I could contact through my mom. So the feeling that I had before is gone. Finally, y'all gave me a chance to get a job. I thank you for that. Got the job, worked as a regular worker. They just upgraded me to a supervisor. Been trying to pay 2 or 3 times a week, a month. You know what I'm saying? I've been clean. I've been happy that I could take care of my kids and do things I couldn't do, which was real hard for me at the time because I was so focused on her. But through these 6 months, y'all kind of fixed me to a different position to see that I can do better without.
So the long-term plan is not to try to reconcile and get back in that situation.
It really just, it pushed me away because if without this, I probably would have been still trying to be in a relationship with her, try to keep my family together. And Mr. Lewis
Sometimes that's not the best thing for the
Mr.
kids.
Lewis had conversations with me as well on the side after coming from court in Houston and saying maybe this ain't what, my dad.
This is the emotional turning point of the hearing. Instead of making excuses, the defendant describes how court-ordered restrictions changed his daily life, giving him distance from unhealthy relationships and allowing him to focus on work and raising his children. Even more significant, both his attorney and the supervising officer tell the judge they've seen a noticeable improvement in his attitude and behavior while on house arrest. That doesn't erase the probation violations, but it does give the court evidence to consider beyond his past mistakes. In probation hearings, judges often have to balance accountability with rehabilitation, and that's exactly what's happening here. What would you do in this situation? Give someone one final opportunity, or conclude they've already had enough chances? The judge is now preparing to answer that question as the hearing reaches its most important moment.
Find that you entered your pleas of true to counts 3, 5, 6, and 7 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. I am going to order that you're on the high risk specialized caseload and that it's zero tolerance. That means you just have to do it all right. There's no hiccups anymore, no contact, communication with Miss Foster. Continue doing what you need to about your kids through your mom. If that's working, then that's great. Use that. If that's not working, then there needs to be something else done. And I would think that to help you guys, it's once you get this taken care of, you need to save up what you can and get someone. You can talk to Mr. Lewis about helping you through the family court system so that y'all have some orders in place with regard to the kids. And there's not all of the communication that you might have to have now because things aren't set on who has what and doing what. But as far as I'm concerned, this is going to be your opportunity. No contact. I'm not going to leave you on house arrest anymore. I want you to go work and do those things. You cannot leave Jefferson County. If she comes to Jefferson County, you better avoid her. If she shows up, you better go lock yourself in a closet and call the police and say, I'm trying. She's bothering me. She can't give you permission to violate my order. Okay. So she can't say, it's okay. Let's just talk about the kids. It's not okay because you're going to end up in prison, not her. Does that make sense?
Yes, ma'am.
All right, so I'm handing you the trial court certification. This wasn't an agreement. You can talk to Mr. Lewis about that. And if there's anything else, Mr. Kitchens, that comes up that you think would be a good condition to add that would help Mr. Barlow, then just let me know. We'll make that happen. Good luck to you. Thanks, Mr. Lewis. Broderick Guillory, Mr. Lewis.
The judge ultimately decides not to revoke the defendant's probation, but this isn't a free pass. Instead, the court continues probation under strict zero-tolerance conditions, making it clear that any future violation could lead to prison. The judge also reinforces the importance of avoiding prohibited contact, remaining within the county, focusing on employment, and continuing to care for his children. Throughout the hearing, the decision reflects a balance between accountability and the possibility of rehabilitation. The defendant leaves court with another opportunity, but also with a clear warning that there won't be another second chance. Whether he succeeds now depends entirely on the choices he makes after walking out of the courtroom. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.
And these, did you go over them with Mr. Lewis? Do you fully understand that?
Yes, sir.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like that agreement that you've reached is for a 3-year deferred probation. There will be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, sir.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection. Yeah.
It's admitted. Is there any evidence that Mr. Guillory is not competent? All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Ms.
I'm looking,
Malvina?
Judge, it looks like what they alleged is not the right word, but what they stated was that the appliances were approximately $1,000 each and the window to be repaired $600. That being said, that's in the offense material. They have failed to, since 2025, submit a restitution request at our letter request. I don't have a problem waiving the PSI if you want to do maybe an amount not to exceed, but that's all the information I have. I will send another letter.
I think
today.
since restitution is a possibility, I'm going to go ahead and get the pre-sentence report done. That way they can also reach out potentially if there's any amounts that get confirmed between now and then, we'll do sentencing then. So again, find sufficient evidence to find you guilty. But what I'm going to do is reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case. More specifically, really about the restitution that could potentially be ordered. So if there's restitution, if there was something that did not get returned or things that were damaged, then that is going to be part of your probation that you pay that back. And so we're going to go through this process so that they can see if they can get those amounts. When you're leaving today, you need to stop and talk to probation. She's sitting at that desk right over there, and then we'll see you back at sentencing in a few weeks. All right. Thanks. You're free to go.
Thank you.
Mr. Rojas, you've got Claredessa Beal. Morning.
Good morning. Please.
Good morning. Are you Claredessa Beal?
Yes, ma'am.
And Ms. Beal is charged with unlawful carrying a weapon on alcohol premises and cause number 26 DCCR 0224. And Mr. Rojas, what is the
Judge,
announcement?
I'm asking for another announcement date. I don't know if this qualifies, but I'm gonna ask Mr. Canal for pre-trial deliberation in this case.
Okay. Any issues?
No, Judge, I mean, have extended an alternative offer if she's not ready for that.
All right. So Ms. Beal, I'm going to reset your case about 30 days or so. So Mr. Rojas can make that request. Stay in touch with him. He'll let you know what he finds out, and then we'll see you back at the next court date.
Yeah.
You're free to go.
Oh.
Corbin Rayleigh. Good morning. Are you Corbin Rayleigh?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Rayleigh, in cause number 25 DCCR 1482, you're charged with the state jail felony offense of engaging in organized criminal activity. And that's from September 28th of 2025. And how do you plead to that charge?
Yes, guilty, right? Sound things. Right.
So did you do this?
Did you do it or did you not do it? If you did it, it's guilty. If you didn't do it, then it's not guilty and we have a trial.
I mean, I committed a misdemeanor under that.
The underlying offense is a misdemeanor assault, Judge, because it was in combination with 3 people or more. He feels it should be a misdemeanor, but Mr. Coleman and Mr. Nichols wouldn't reduce.
And you've talked to him about
We have.
what engaging in organized criminal activity means.
We have.
So you've gone over all of this with Mr. Rojas, right?
A little bit, yeah. I just.
All right, I'm going to hold the case. Y'all go talk
Yeah,
Ask any questions you have of Mr. Rojas. Listen carefully to his answers. He's
Yeah.
telling you what the law is, and then we'll decide, you can decide if you want to take the deal or not, or if you
Yeah.
want to go to trial.
They haven't been there to tell me nothing. I've been dealing with Mr. Lewis about 8 years. And like I told him, he done told me a lot of father figure things that kind of dawned my brain that I couldn't even focus on without another male person that's in a good position in life to kind of direct me. So it kind of put me in the right stand. And Mr. Kitchens always was out to hear what I had to say. And I appreciate him as well.
Well, here's the thing, Mr. Barlow, if I give you this opportunity today, you've got to take advantage of it because you're not going to get this opportunity again. You've got everybody behind you. Mr. Lewis has worked very hard. I've signed, I don't know how many times he's sending over emails. Can he go do this? He's got a job. Can he? And I want you to do all those things that are positive, but you've got to stay on the positive track when things kind of lighten up a little bit eventually on probation. You're going to have to do it on your own. So what I'm going to do, I'm going to